You're listening to Federal Prison Authority presents Around the Block with Bruce Cameron and Susan Giddings, only on LA Talk Radio.
All right, everybody. Well, hello, and welcome to another exciting episode of the Concierge Coaches Show.
No.
Also called Around the Block. There we go. And we have a great show for you today. We have some question and answer from our Facebook group, and then we're going to go into home confinement and
direct home confinement
and direct home confinement.
Yeah.
So
all right.
Susan,
we posted last week to the Facebook group, and we got some questions. A lot of interest in what's going on with the Sentencing Commission. And let me start with Bruce and I are not experts on the sentencing guidelines, so I don't want to. I won't pontificate about that, but I thought it would be good to talk about the process. So when, because everyone's focused on November 1st, and November 1st is an important date. The way the commission works is they set an agenda for the year. They work through some amendments. There's public comment and public meetings, and they decide on amendments, and they vote to send them to Congress. And once those are voted and they send them to Congress, they wait. And if Congress does nothing, then they become active. If Congress votes to block them, then they don't. So essentially, if Congress does nothing, then they just roll into and they become the new sentencing guidelines, or whatever those amendments are. Had a specific questions about retroactivity. Did a little research beforehand. On August 6th, there was a public meeting and a vote regarding retroactivity on the amendments that are in the hopper right now to become live in November. They did not vote in favor of retroactivity. It was a split commission vote. After this show, I'll post a link to the page where the public meeting was. It was about 40 minutes, but you can listen to it and hear the discussion. So
will some of these be retroactive and some of these not, or it just depends? Or
the ones that what was voted on was regarding the adjustments to the drug, I can't remember what amendment it was, 833, 830, whatever it was. And they voted to not make that retroactive. And several of the commissioners spoke both in favor and against retroactivity and their rationale for that. So at least for now, that is, it appears to be a non-issue.
Okay. So again, these are sentencing guidelines set forth by the court. So whatever they decide, the BOP will then follow suit and make adjustments. But it's not the BOP that does this. This has nothing to do with the BOP. Just like the 821 thing, that's between the court and the person. And so I think people, November and it's new laws are not right. Laws.
Right. There is no new law at all. So, and in listening to the discussion, I did take a couple minutes to listen to it myself, and it came down to, and again, not an expert on guidelines, but it seems the new amendments, in order for the lower sentencing range to kick in, there's an issue of mitigation. And the commission, some of the commissioners felt that it wasn't a straight up change in the guidelines in terms of drugs, the relevant drugs and the amounts and the ranges, but it was, if this mitigation is present, how much lower can they go? And from the gist of the conversation, it was that mitigation is already taken into effect, that the sentencing courts already have that authority to address mitigation and going below the guidelines. So that was the gist of what I picked up on. But again, we're going to post it to the Facebook group. And so any of our members, and we can go ahead when we post to the YouTube channel, we'll go ahead and post it, link there as well for folks to be able to hear the discussion themselves.
Now we had some other questions that at least one, if not two or three, where the person had like 12 or 13 or 14 years, and how much FSA time and how much, and what am I going to get or whatever. Well, that just depends, right? Because if you had a medium or high pattern risk and you weren't in earning status, and then we can't answer those questions just perfunctorily. So just to let y'all know that
it really concerns me when other folks, like, you see the estimates all over the place, and some folks who are on our Facebook group but are now either on release or are in the community and are able to participate, they've shared, well, I did X number of months on this kind of sentence, and then others are throwing out formulas, and we kind of caution against that. There's too many factors. A lot of folks will see the things, well, my loved one is looking at X number of months, what's it going to serve? And someone invariably within one or two comments will say, well, with FSA and RDAP and da-da-da-da. And you kind of got to go, well, wait a minute. Hold on. For RDAP, there is an eligibility to participate. You actually got to have a substance abuse issue. So that's the first step. And then you also have to be eligible for the 3621 early release benefit. The criteria to get in the program and the criteria to get the time off is two different things. Right. So I kind of always caution people against that. The other question in terms of calculations, well, how much SCA time am I going to get?
There you go.
And again,
the wild card.
The wild card.
The Monopoly money card.
And of course, we just had someone have a conversation with us a little earlier this afternoon and explaining that their expectations were unrealistic. So, as everybody knows, if you're listening to Bruce and I, because we talk about it a lot, SCA is not guaranteed. That's number one. You are eligible from nothing to 365 days. And we talk about the 5-factor review. And I will tell you, a lot of case managers, when they're talking to, loved one about release plans, they may not specifically say, okay, having conducted a 5-factor review, this is what I determine. Excuse me, sorry.
Right. It's okay.
But what are the factors, that come into play with that Second Chance Act? What are those 5 factors, right? Mm-hmm. We're looking at offense. They are looking at offense. They're looking at your history. They're looking at the institutional adjustment. They're looking at release needs. They're looking at recommendations as part of supervised release. Within supervised release, is there certain things in there? Once the unit team makes a recommendation and it goes through everybody in the institution and it leaves to go to the RRM office, now they're reviewing what the case managers wrote in the referral, but they're layering on that 5th one, which is resources. Local resources. And as we've talked about just a million times,
like
local resources include, it's like booking a hotel. If there's no room, there's no room. They're not going to put you in the lobby, right, on a cot. They're just going to say there's no room. So it's bed space. It's electronic monitoring equipment. It's contract capacity. And that's something the Bureau is working on currently is to expand that home confinement contracting capacity. Under the CARES Act, the CARES Act kind of lifted the restriction on contract capacity. To what extent, I don't know. I'm not going to venture, but the Bureau was able to move a lot more people into home confinement under the CARES Act. But once the CARES Act went away, that extended home confinement authority went away, but so did the kind of waiving of those contractual issues, or I should say, maybe not waiving of the contractual capacity issues, but expansion of them, allowing the Bureau to go further above contract capacity in order to put more people out there. And that is just a reality.
Now,
Staffing guidelines. If a halfway house fires a bunch of people, fires a bunch of their staff, they have staffing ratios. So that immediately interferes with how many folks that they can accept. So all of those factors come into play. We told someone this afternoon before the show, their loved one had a 21-month sentence and thought they were going to get 6 to 9 months of halfway house. When one, they didn't have any residential needs. They had a home to go to. So the case manager was looking at direct home confinement. And we're going to talk more about the criteria for direct home confinement later. But 6 to 9 months of halfway house on a 21-month sentence is unrealistic. It's just, it's not happening. On a 21-month sentence, even someone with a lot of release needs might be looking at 4 to 5 months. Someone who's homeless might be looking at 4 or 5, maybe 6 months. That would be pushing it, right? Because they're already getting good conduct time. They're already getting FSA credit. And then they're looking at pre-release placement. Second Chance Act is about pre-release placement. Now, the Bureau has said, in order to maximize home confinement, in that infamous June 17th memo, right, it was those folks that don't have the need to go to a halfway house. They have a residence, they have a bed, they have some place to go, right? They're looking at direct home confinement and maximizing direct home confinement by applying the number of home confinement eligibility days to that conditional release date. That's what they're looking at doing, applying to that conditional release date, as opposed to what they were doing before and have been doing forever and ever and ever.
Forever.
So that's where, we got to separate. It's not about earning or entitled in terms of Second Chance Act. So, yeah.
The other thing I want to, it's funny, your texts are just now coming through from before the show. It's amazing. Wow, what a country. Just coming across the screen. So the other thing I wanted to bring up with that in terms of, you said about availability and resources is, I think, and correct me if I'm wrong, a lot of that's some of that expansion is tied to the passage and actual funding of the big, beautiful bill, right?
There is. Sure? Yes. There is. I don't know how much, because I haven't sat there and read it. But there is additional resources in the budget bill that was passed. But people also need to understand that just because the president signed it doesn't instantaneously have it released to the Bureau. The process, when a bill is signed into law, in the case of a budget bill, the Treasury first distributes those funds to the department level. So Main Justice gets it in the case of the Bureau. Those cabinet level departments are getting their cut of the pie. And then they start that distribution process. And eventually the Bureau gets their cut of the pie. And then they start distributing it down from that department level to the divisions. In the case of halfway house, it would go over to the reentry services division. And then the distribution goes out to the different reentry offices. Now, the funny part to them waiting so late for Congress to kind of get their act together and get a bill passed is...
because we have a new fiscal year coming up in October 1, right?
Right.
In theory.
But the institutions, and I can't speak for the RRMs, and because a lot of the RRM stuff is guided by contract, so let's set that aside. Right. It is typical that you will get at the institution level, the cutoff for spending is somewhere around the second to third week of August. because everything has to come in and get reconciled and be done by September 30th. There is no wiggle room in terms of that going on. So while the budget was passed and the Bureau got money, how much of it will materialize, how fast those funds will materialize into, in the case of reentry, beds and monitoring equipment? That's a good question. Because nothing happens fast in government.
That's right. That's right.
It's just not how it works.
But at least there's help. Help is on the way, so to speak, and
absolutely,
with the passage
100%.
of that,
and they're aware of the problem, and in terms of the contracting process, that is something that the powers to be, not in the bureau, but above the bureau, they understand that one of the challenges is how slow it takes to get contracts done. It can take up to 2 years for a new contract. Now, contract expansions are a little bit modifying an existing contract is a little different and a little quicker, but still, it's a process. Again, nothing happens quickly.
No, it doesn't. So
going back, I was gonna just one other comment with the calculating. Yeah. So there is no calculating like some magic formula for Second Chance Act. We know how FSA is calculated. When folks are looking at their loved one situation, understanding jail credit versus sentence is also important when it comes to FSA.
Right. Because that jail time credit won't necessarily be on the FSA.
It won't be on the FSA at all, because you don't even start the FSA process until you get to your institution, complete the risk and need assessments, determine your eligibility. All of that is entered in, and you start programming. So if you're sitting in a jail for 3, 4, 5, 6 months or longer in the pre-trial phase,
sometimes an MDC or FDC, you might sit, if it's not your designated joint, even though you're in a federal, you're not. Go ahead.
Even though you're involved, those detention centers, their primary mission is to support the U.S. Marshals pre-trial mission. And if you're pre-trial, none of that time counts. Even if you stay busy and stay out of trouble, and that's important, none of that time counts. It counts toward your sentence. Right. It doesn't count toward FSA time, because those are actual programming days. So, just like I said, I always kind of cringe when I see the flurry of comments and you've got a family member hanging their hopes on, he or she's only going to be there X amount of time. And I kind of want to go, well, maybe.
So, yeah. So that's okay. So folks, that's that with the jail time credit versus the FSA credit. You got to be in earning status in your designated institution. Now, switching gears a little bit, for what we were alluding to just a minute ago, we had a call earlier today, and the lady was concerned. Hey, that's not fair. If this person's in home confinement, they could be in get more halfway house time. Well, you're still serving your sentence. It just depends, where are you going to serve your sentence? The institution, the RRC, or home confinement, okay? Or the home confinement side of RRC. So your sentence is your sentence, okay? Now, I'm kind of interested, and I won't spend too much time on it, but let's say person X is a person of means. They don't necessarily need a halfway house, so they just go to direct home confinement. But their sentence was in such a way they didn't have a lot of home confinement days. But they could have gone to but I could have gone to the halfway house maybe 2 or 3 months earlier. I could have been in the community, not on home confinement, but I could have been in the community for 2, 3, 4 months or more, depending, and then gone on home confinement once I hit my home confinement eligibility date. So are we going to see any kind of kerfuffles?
Yes, probably. People aren't going to like to hear that, but I will tell you, prior to the passage of FSA, many minimum security individuals who often have a home to go to, a lot of times have a job waiting for them, were going to direct home confinement. That was pretty much the standard, because the reality is it's cheaper to be in a minimum security camp than it is to be in a halfway house on the average. So for individuals that didn't have need, they were looking at direct home confinement. What happened was, with the passage of FSA and this earned credit and moving release dates, what was happening was individuals with less than 365 days weren't getting to use all of their home confinement eligibility. If someone had 60, 65 days of home confinement eligibility, they were lucky if they got 30 days of it, because they had to wait till their release date moved enough and their home confinement date moved enough to put them in halfway house. And case managers were putting people in halfway house in advance of that date so that whenever it moved enough, they would be able to go. So what happened? Well, let's think back to last year and a big chunk of this year. What was going on? We had no bed space, and people were getting 30-day placements when the unit team had recommended 5 to 6 months, because that's all there was. There was no beds. And we had this kind of bogging down of the system because of the time credit issue, kind of in the monthly moving before we could move someone to home confinement, right? That was a problem. That was becoming a real problem while I was still working, when the conditional release dates calculators rolled out in 2023. The writing was on the wall that it was going to get bad once the conditional placement calculator rolled out. Excuse me. And it did. It got really bad. Some folks didn't get any time at all. And again, because of this kind of rolling release date we were dealing with, and the rolling home confinement eligibility date, then they were left with a home confinement eligibility by the time it actually rolled around, that they only really had 27 days left. 20 days left. We had one case, I think the person ended up with about 14 days, 15 days of home confinement eligibility. The Bureau started trying to mitigate some of that. One of those things, in June of this year, they were able to, I think it was June. Yeah, it was June. Or was it May? It doesn't matter. This summer, it was late May, early June. They were able to refine the coding for the calculator so that it could be run monthly or nightly, so that individuals weren't having to wait to the end of the month in order to get their data. Excuse me, I'm sorry.
You don't have to push the button anymore. You don't have to push the button.
It was running nightly. That alleviated some of that. At least folks were, as soon as they were getting their 30 days, their date was moving, which means their home confinement date was moving, as opposed to waiting another week or two until the end of the month, or 3, whatever it was. That helped. But the real kind of flip the switch change was the June 17th memo from Director Marshall that said, we're going to, SCA and FSA authorities are going to be applied cumulatively and in sequence to include home confinement. Huge deal. We were talking about that while I was still working. And there was a question of whether the Bureau could legally do that. Because, again, what they're doing right now is they are attaching that home confinement eligibility based on the conditional release date. And of course, the conditional release date includes both earned and unearned credit. So my guess is Maine Justice gave them the green flag to do it, and they rolled it out. So it was a good thing.
And again, that's a projection. Still, though, it's still a projection, because some of that date is based on stuff that is not earned yet, right? So just, you know what I'm saying? Because people will see a date on a piece of paper. I think they got it coming.
They got it coming. So and of course, with the new calculator, as soon as someone is in earning status and the conditional calculator runs, they're getting information that right now is years out, like way out. And they're like, oh, that's gospel. Well, a whole lot of things could happen.
Yeah. Yeah.
We had a
We've
client that
seen a whole lot of 100 series shots derail some folks. Go ahead.
100 series shots. We had a client that ended up in the local hospital and was out of pocket for a few weeks. That changed his programming days, because that calculator, those conditional calculators, all three of them are based on the presumption that once you're in earning status at the current rate, which means if you're only at the 10-day rate, when you go to the 15-day rate, everything changes. It is based on a current snapshot when it's run. And the presumption is, okay, you're in earning status, you'll keep staying in earning status, because why would anybody jeopardize their earning status?
Right.
And that's the presumption. So, all right. We did have a quick question about how long should someone kind of expect that halfway house, once the paperwork leaves the institution, how long does they expect it to take? We tell everybody 4 to 6 weeks or 30 calendar days. That's a ballpark. That is not gospel.
That's a ballpark.
It's a ballpark. Generally speaking, absolutely. Generally speaking, it can take in that range of 4 to 6 weeks. Does it happen faster? Sure, it can. Can it take longer? 100%. A lot of it comes down to, again, availability in that local area, because what happens is that packet comes into the reentry office and their first go-to is closest to the person's home. Well, if closest to the person's home has nothing and no availability for months, they're going to go to the next one. They're going to look around. If a person, we do have individuals with offenses and histories. They may not be earning FSA, but their criminal history, their current offense is such that it may be more difficult to place them. A lot of halfway houses, depending on their location in terms of their proximity to schools and churches and playgrounds and such, will not be able to take sex offenders. So again, if when that packet comes in and this individual has either by current offense or criminal history, has some sex offense behavior, and they've got to figure out where to put that person, it may take a longer placement. So that becomes an issue. We also had a question, and the person phrased it as early release or hardship release. Okay, so first off, let's say there is no such animal. Okay, can you apply for clemency through the executive?
I posted the link in that thread. Yeah, go ahead. Yeah,
right. Yeah. So that's executive clemency. That's the president. Bureau has nothing to do with that. There is a policy, we've discussed it before, for an expedited review if the application is turned into the case manager, and then the case manager pulls together some documents and the warden signs off on a cover memo. But it's still, that's a lottery ticket. You can't win if you don't play, but that's nothing to count on. Compassionate release or reduction in sentence is available. It is got a very high bar. Obviously, traditionally, it was available for individuals who were at end of life stage in terms of cancer and other diseases, and they were terminal. And it used to be it was 6 months. You literally had to have a diagnosis, prognosis of 6 months or less. That's gotten a little not as clear cut, not as I shouldn't say it's not a bright line. You have to have a prognosis of less than 6 months, but you do need to be in an end stage disease that will result in death. But they've also expanded it to include cognitive issues. So Alzheimer's, other forms of dementia that are degenerative and aren't going to get better. They talk about ADLs, activities of daily living. Is the person confined to a bed? Are they Can they eat? Can they feed themselves and use the bathroom facilities on their own, get out of bed and things like that. There is also a provision, but it is an extremely high bar to meet, having to do with dependent care. This is not just
you can't have any family members within 500. What is it?
You can't have anybody that is also whether it's children, minor children, or say an elderly parent. If there is anyone else, the expectation is other people can step up. It doesn't have to be you. Like I said, it is a very high bar to overcome. I guess it was 24 and 20.
Now, is it more difficult for folks in mediums and USPs?
It is, yes. The more serious, I would, not just because they're in a USP or a medium, but because they are individuals in USPs and mediums are more likely to have violence in their background. And while having, say, some issue of violence in your background doesn't automatically preclude you. One of the things in terms of the bureau process, when an individual submits a request, one of the things the warden considers in that recommendation to go up to the next level is likelihood to commit another crime. Like, are you still a danger to society? And that's wardens take that responsibility in signing off on a reduction in sentence application very, very seriously. Now, under the FSA, it did provide folks an off-ramp to not have to go through the bureau process. You still have to initiate through the bureau, but if at any point in the process, either at the initial request or any of the appeal phases, because a denial is open to appeal, but at any phase, the response takes longer than 30 days. On day 31, the individual can go directly to the court. So that is the off-ramp that was provided for within the First Step Act. Now, I will say one other thing with that, and it was the way the First Step Act was written, and Congress has not amended this part of it. This only applies to new law folks. So if a loved one is an old law, and there are some still out there sitting in an institution, they cannot use the 30-day off-ramp. They have to go through an exhaust administrative remedy. Like I said, the way the law was written, it was kind of funny. I was reading an article from one of the senators, and who shall remain nameless, said, well, we didn't mean for that. And I kind of had this flash in my mind back to when they passed the new law, and they said an individual would earn 54 days of good conduct time for each year served. And the Bureau said, okay, and calculated it accordingly. And it took until 2018 in the passage of the FSA to change it to 54 days per year sentence. And for years and years and years, it was, the Bureau misinterpreted what we meant. And it was, well, that's not what you said. So whether or not that gets corrected, I know that was, has been discussed. I think it will get bipartisan support if it actually makes it through to an actual bill. But that's where they are at right now. So yeah, hardship, and that just doesn't exist. Those are your two options, and both of them are pretty narrow. So I didn't have any other questions. Did you see any others?
So back to, I'll just say generally, right? Mm-hmm. So maybe we should just have a little micro general discussion. I know you don't like to do that, but people,
because everything is so detailed.
Yeah, no, it is. But look, so you get in, somehow you get into earning status,
mm-hmm.
right? And you get 10 days for the first 6 months.
If you have more than 12 months sentence.
If you have more than 12 months, 15 days thereafter. Okay.
Right.
So now, is that was that? How much do you need to serve to get a full year off your sentence?
You need to
24?
have,
25?
when you walk in the door, you need to have 39 months in front of you, because you have to serve 27 months to earn 365, but then you still have to have the 365 remaining to serve, because you have to have, well, you say that like it's obvious. We have to explain that. Yeah, we have to explain that a lot, is it's the time remaining to serve. So yeah, when you walk in the door, your GCT, good conduct time release date, needs to be at least 39 months out. And that's the 27 months to earn the credit and the 12 months remaining to take it to reduce it.
I think that is a very meaningful snippet that we should just have on a continuous loop on our Facebook group. At least it's a starting point for people to kind of figure out, okay, given that scenario, my loved one has this a longer sentence or shorter sentence or whatever, and then can kind of at least have some sort of educated.
And even though we've been talking about it, and by we, I mean you and I in this setting, but also me, when I was still working, have been talking about this since 2022, since time credits started rolling out. There were numerous habeases that I had to write declarations on, where the person literally was like, oh, from here to my release date is this many months, and this times 15 days. That means I've got this much time. And I can remember some of those early ones that like they had come out and like, I should have 1,722 days, and they were prorating it and the partial credit and all of these things. And I was the bearer of bad news, to go, yeah, no. And then there were some folks that came up with calculations that I couldn't even, if I could follow how they calculated it, then I could at least explain where they went off the rails a little bit. But there were some that I couldn't even figure out, like, because they didn't explain it. They just said, I should have this many number of days.
That is a great thing. I get mail all the time. I share it with you. I scan it. We look at it together. What is the most common mistakes inmates or family members make when it comes to these calculations, their homebrew calculations? Where do they usually fall off the rails?
A lot of folks will take the number of days, like we see proration going on, and they'll just take, well, it's from here to here, and that's this many days, and divide that by 30. And what happens is, and they look at the whole sentence at one time, as opposed to what you and I do is we take the date of arrival. Do you have less than a year or more than a year? That determines, do you do 118 days or 208 days? And then, of course, because the overnight calculations, we know at the 210th day and the 100 and what was it? I just forgot it. 120th day, the new days kick in. We get a new conditional release date. We calculate it based on those. We don't look at the full sentence. We literally, okay, this is what's left. And then as the kind of quick hack that we look at when we're trying to talk to someone on the phone and they are adamant that there's more time, is once you move to 15 days, whatever day you move to 15 days to your release date at that time, not your good conduct date, because you've already had time come off your sentence. So on the day you move, from the day that you hit your 15-day earning rate to your FSA release date at that time, it's about 1/3, because you have to serve 2 months in order to earn a month. So we usually say divide by 1/3. So and it gets closer.
So again, you want to rewind and listen to that again, because I know we have a book. Our first Step Back book is fantastic. But if, some people like to hear these things.
Absolutely.
I'm a guy, I have to read it and contemplate it and read it. I mean, I can listen okay, but I still have to take notes you know.
Right. Well, and when I first started working on this, trying to like think about the conditional calculator, right? And I was still working, and in my office in DC, I had a very, very large whiteboard opposite my desk. It was like 4 foot by 6 foot. And I spent the better part of about 3 hours mapping sentences out because I knew I needed, when I was talking to case managers and case management coordinators, and when I was just scanning mail and looking at habeases, to quickly know if the person was like close or are they way off. I needed a formula. And I spent the better part of 3 hours drawing it out on the whiteboard and mapping out. And then when I had what I thought was a formula that worked, well, then I had to try it on different sentence patterns. So, I usually, and you've seen me do it 60 months, 120 months, 20 years, 5, 10, and 20. And I was mapping it out to see, did it hold up? That's why when I see these calculators online and people are like, oh, and I'll be like, I've tried that one, and I've seen 2 or 3, and I keep coming back with they're close-ish. One doesn't take into account the good conduct time correctly for 12 months versus 12 months in a day. So I see errors in those. So
right, and that's.
But the Bureau's calculator is correct, and I don't know how much clearer I can say this. It is correct. Now, if there's errors with regard to programming days or disallowance days, that's different, because it's still garbage in, garbage out. So if there's a bad date coming in or bad information coming in, but the calculator itself works both for the conditional release date, the conditional placement date. In fact, they did at the same time, when they were working on tightening up so they could run it nightly, they also tightened up the estimate at that tail end of the sentence. And we talked about that several weeks ago. So the calculator works.
Yeah. So many times we said to the client or to their family, get down to psychology immediately and get fixed, get your stuff fixed. If there was an error, like you said, if they input something or they misinput something, but the calculator itself is correct. So that's a great point.
Right. The calculator works. I know there are some naysayers out there who still think it doesn't work, but the calculator works. As long as there's good data in, it works.
Oh, yeah, get some hate mail for that. You're going to get some hate mail.
I know.
On your social media.
I have one fan that loves to send me hate mail. Hey, really quick, we just have a few minutes. I want to talk super fast about direct home confinement.
Please, yes.
So we are talking about direct home confinement, not general home confinement. The Bureau is looking at individuals for direct home confinement. We posted this last week, the slideshow, the training slideshow, which is available on the public website. Currently, it's in kind of a weird place. Eventually, it's going to move over to the FSA page. That's why we posted a link to the Facebook group. Please take a look at it. A lot of good information on there. But they keep talking about eligible inmates. Eligible. And they said eligible once. They said it like 10 times. So very quickly, for direct home confinement, doesn't have a public safety factor. If you've read our Unlocking Federal Prison Designation and Custody Classification, we have a whole section on public safety factors. Can you be in minimum security camp and have a public safety factor? Yes, it's been waived so that you could move to a camp, but you could still have a public safety factor. You see a lot of that applies to a lot of folks in lows and above. Central inmate monitoring. If you have if you're a pure separation case, and we don't talk about SIMS a lot on here. If you're a pure separation case, meaning there's somebody you're not going to be locked up with, this doesn't apply to you. But if you have any of the other assignments, disruptive group members, threat to government official, broad publicity, and for campers, for minimum security inmates, right? You could be in a camp and have a broad publicity assignment. What does that mean? Broad publicity assignment is very simply either by virtue of who you are, Martha Stewart, everybody knew who she was, or your offense garnered a ton of media interest. And by a ton of media interest, we're talking, local, national, regional news. You got a Wikipedia page, that kind of thing, broad publicity. So that kind of plum shot. Now, it doesn't preclude you from getting home confinement later. This is direct home confinement.
Direct.
This is leave the
institution. Don't
institution.
panic, everybody. Right.
Yeah, don't panic. This is leave the institution and go. This doesn't preclude you from Second Chance Act placement. This doesn't preclude you from eventually getting to home confinement, but they're going to put you in a halfway house first and see how you do. Third thing, and it kind of falls into, could fall under broad publicity, but if you're like slightly below broad publicity, but you are still a high profile or sensitive case. And the way the language and the policy reads, and I'm going to read it exactly, sensitive or high profile cases, or one which might generate undue public concern. So if it is going to generate undue public concern, the Bureau is not going to look at you for direct home confinement. History of escapes from halfway house or prior halfway house failures. So if you were in a halfway house and you got yourself in trouble and you came back to an institution, do not expect to get to go to direct home confinement. Again, doesn't preclude you from a Second Chance Act placement, doesn't preclude you from possibly being able to go to home confinement once you've demonstrated good adjustment in halfway house. So I also don't want everyone to think that they're automatically getting, particularly for individuals with a little longer sentences, they've got maybe 4, 5, 6 months of home confinement eligibility, that's a foregone conclusion as well. Got to be eligible. And with that,
3 minutes.
We have 3 minutes. So again, we've covered these things, and these are not new topics, but again, it always helps to hear them again. Bruce, you want to talk about our books? Show them off?
Sure. There we go.
We refer to them as the blue book and the green book. The blue book, Unlocking Federal Time Credits, second edition. When you do a search on Amazon, if you don't say second edition, it will go back to the first edition and it will say it's out of print. And then the green book, Unlocking Federal Prison Designation and Custody Classification, also available on Amazon. For those of you who are in a pretrial phase, put your hands on this. This is important.
Right. And then if you are going to be FSA eligible, you want to get both. But
right. Absolutely.
But for sure, you want to do this first to make sure your PSR is correct and all this sort of stuff.
And there's good information in there, even if you're sentenced already, because the first half of the book focuses on the current classification instrument and how the Bureau views each of those different things and what they're looking at when they're assessing your custody classification. Yeah,
I was going to tell you real quick. I got a call yesterday from a former BOP inmate who is a paralegal for a large law firm who they got our books and they're using our books for all their federal cases. So I thought that was awesome. And so, well, good. Well, everybody, thanks for tuning in for yet again another informative and wonderful episode of Around the Block. You could see us and hear us on Apple Podcast, Amazon Audible, and of course, we're archived on the LA Talk Radio site, latalkradio.com. Find the show. We have the MP4 you can actually download for free. You can listen to us. You can see us and all that good stuff. But we're also on those podcast aggregators. We're going to observe the holiday next week, but we'll be back the week after.
Excellent.
So we hope, I know, right? So that'll be fun. So everybody be good. Continue to come to our Facebook page. We have a YouTube channel, First Step Act on YouTube. And so post your questions. We'll continue to get back with you. So have a great week, everybody. And we'll see you here next time on LA Talk Radio, Around the Block. Take care, everybody. See you.
Take care. Bye-bye.
You're listening to Federal Prison Authority presents Around the Block with Bruce Cameron and Susan Giddings, only on LA Talk Radio.